Welcome to Chapter 9 of Criminal Procedure. This chapter covers eyewitness and scientific identifications, two of the most important and frankly most fascinating topics in the entire course. We talk a lot in criminal law about the presumption of innocence, about the burden of proof, and about the idea that it is better for 10 guilty people to go free than for one innocent person to be convicted. This chapter is where those principles get put to the real test. Because the evidence we are going to examine today, eyewitness testimony, is the single greatest cause of wrongful convictions in the United States. Not false confessions, not planted evidence, eyewitness testimony. By the end of this lecture, you are going to understand why that is. You will understand the constitutional rules the Supreme Court has developed to address it, and you will understand how scientific tools like DNA have both solved the problem in some cases and created new legal questions of their own. We have two major areas to cover today. First, eyewitness identifications, including the psychology of why they go wrong, the best practices for conducting them, and the Sixth Amendment and due process rules that govern how courts treat them. Second, scientific identifications, the legal standards for admitting scientific evidence at trial, the rise of DNA evidence, and the continued controversy over polygraph tests. Let's get into it. Before we dive in, let me walk you through what you should be able to do by the time you finish this chapter. Objective 9.1 asks you to understand the connection between eyewitness identification and wrongful convictions. We will spend real time on the data here because the numbers are striking and they explain why this entire area of law exists. Objectives 9.2, 9.3, and 9.4 are all about the Sixth Amendment right to counsel. The core question is, when does a criminal defendant have the constitutional right to have their lawyer present during an identification procedure? The answer is more limited than you might expect, and it turns significantly on timing, specifically whether formal criminal proceedings have already begun. Objectives 9.5 and 9.6 move us to the due process framework. Even when there is no right to a lawyer, the Fifth and 14th Amendments still protect suspects against identification procedures that are so unfair they create a real risk that an innocent person will be misidentified. We will look at how courts apply a totality of the circumstances test to make that determination. Objective 9.7 addresses an important limitation. The due process protections only apply when police are responsible for creating the suggestive circumstances. We will look at the most recent Supreme Court case in this area from 2012, which drew that line clearly. And finally, objectives 9.8 through 9.10 take us out of eyewitness identification and into scientific evidence. We will cover the two main legal standards courts use to decide whether scientific evidence is reliable enough for a jury, the Frye test and the Daubert test, and then apply those standards to DNA evidence and polygraph evidence. Throughout all of this, I want you to keep one overarching question in mind. Is the Supreme Court striking the right balance between protecting individuals from wrongful conviction and giving law enforcement the tools it needs to investigate crime? That tension runs through every single case we will discuss today. Let's start with the basics. When law enforcement tries to identify the person who committed a crime using a witness or a victim, they typically rely on one of three procedures: lineups, show-ups, or photographic identifications. A lineup involves presenting a group of individuals, typically 6, to a victim or eyewitness and asking whether any of them is the person who committed the crime. 5 of those 6 people are what we call fillers, foils, or distractors. They are people who are known to be innocent of this particular offense. The question the officer asks is deliberately open. Did any of these individuals commit the crime? That open framing matters because asking, "Is it number 3?" would be inherently leading. A show up is a one-on-one confrontation. One suspect, one witness. The police present a single individual and ask the witness whether this is the person who committed the crime. Show-ups are widely criticized as suggestive by their very nature, because the act of presenting a single person implies that the police believe this is the perpetrator. We will come back to that criticism repeatedly. A photographic identification, sometimes called a photo array or a six-pack, works similarly to a physical lineup, but uses photographs rather than live individuals. The witness is shown at least 6 photographs of similar size and appearance, and asked whether any of them depicts the person who committed the crime. This is the most common form of identification procedure in use today, primarily because it is logistically easier than assembling a physical lineup. There's also a fourth category worth mentioning: scientific identification. This includes fingerprinting, DNA analysis, hair and fiber analysis, and other forensic techniques. A real-world investigation almost always uses a combination of eyewitness and scientific identification. They are complementary tools, not alternatives. And before we move on, it's worth noting the multiple functions these identification procedures serve. They narrow the field of suspects, they can exonerate innocent people before charges are even filed, they provide a basis for indictment, and they build confidence in the criminal justice system by giving jurors tangible evidence to evaluate alongside other proof at trial. The exoneration function is one that often gets overlooked, but it is just as important as the identification function. A witness who says, no, that's not the person, is doing the justice system an enormous service. Now let's talk about why this matters so much. And the answer, backed by decades of research, is this: eyewitness misidentification is the single leading cause of wrongful convictions in the United States. Not planted evidence, not prosecutorial misconduct, not junk science, although that is a contributing factor in many cases. The number one cause is an eyewitness who sincerely, confidently, and incorrectly identified the wrong person as the perpetrator. Let me give you the numbers. Studies of wrongfully convicted individuals consistently find that misidentification was involved in somewhere between 64 and 79% of cases, depending on the crime. For sexual assault cases specifically, the figure is around 90%. According to the National Registry of Exonerations, mistaken eyewitness identifications were a contributing factor in roughly 30% of all exonerations in 2017 alone. And the racial disparities are stark. Inaccurate eyewitness identifications were present in 79% of sexual assault exonerations involving African Americans, compared to 51% involving white Americans. How is this possible? How can so many sincere, well-intentioned witnesses get it so wrong? Psychologists point to 3 categories of factors. First, crime factors. The crime itself may make accurate observation difficult. Many crimes are brief. A robbery may be over in 30 seconds. They often occur in low light, at night, or in chaotic circumstances. The victim may have had only a few moments of actual face-to-face contact with the perpetrator. Second, victim and witness factors, Even when a witness has the opportunity to observe, fear and stress impair memory and perception. There is a well-documented phenomenon called weapon focus. When a gun or knife is present, a victim's attention is drawn overwhelmingly to the weapon rather than to the perpetrator's face. Add to that the tendency to perceive what we expect to see, biases and assumptions we carry about who commits crime, and the simple fact that most of us are not trained observers. A victim may be able to say someone was tall and heavy-set, but unable to describe their facial features in any useful detail. Third, offender factors. Cross-racial identification is particularly unreliable. People are consistently worse at accurately identifying faces of a race different from their own. Perpetrators may also take steps to disguise distinguishing features, commit crimes in darkness, or work in groups in ways that divide the witness's attention. And then there's memory. Unlike a video recording, human memory is not a passive archive. It is reconstructive. It changes every time we access it. Memories fade. They merge with new information we receive after the fact, and they can be altered by suggestion without the person even realizing it. We'll see that dynamic play out dramatically in the next case study. In June of 1984, a man broke into Jennifer Thompson's apartment in the middle of the night and raped her. Thompson made a conscious, deliberate decision in the midst of that attack. She was going to memorize everything about her attacker. She maneuvered him into lighted areas. She studied his face, his build, his voice. She was determined that he would be caught and convicted. Afterward, she gave police a detailed description and worked with investigators to produce a composite sketch. A few days later, she was shown a photo array. She selected Ronald Cotton. She was confident. Then she identified him in a physical lineup. Again, she was confident. She later said that Cotton looked exactly like the man who raped her. Cotton's alibi didn't hold up. Physical evidence at the scene was consistent with him being the perpetrator. A forensic expert testified that the rubber on Cotton's shoes matched rubber found at the scene of the crime. Critically, he was the only suspect. The other 6 people in the identification parade were government employees. In 1986, Thompson took the stand and identified Ronald Cotton as her rapist. The jury convicted him and sentenced him to life in prison. In 1987, the conviction was appealed and a retrial was ordered. At the retrial, a second rape victim from the same night who had previously passed over Cotton in a lineup now came forward and identified him. Cotton's lawyers argued that another inmate, Bobby Poole, had bragged about committing the rape. Thompson looked at Poole and told the jury she had never seen him before in her life. Cotton was convicted again, 2 life sentences plus 54 years. In 1995, DNA testing proved that Bobby Poole was Jennifer Thompson's rapist. Ronald Cotton was completely innocent. He had served 11 years in prison for a crime he did not commit. Poole confessed. The governor of North Carolina pardoned Cotton. Here's the detail that should stay with you from this case. Jennifer Thompson later wrote that even today, when she thinks of the man who raped her, she still sees Ronald Cotton's face, even though she knows with absolute certainty that Cotton is innocent. That is how deeply and permanently the identification process had corrupted her memory. She did not lie. She was not careless. She was a careful, motivated, highly engaged witness who did everything that she thought she was supposed to do, and she still sent an innocent man to prison for over a decade. This is why the law takes identification procedures so seriously. This is why we have constitutional rules. This case is not an aberration. It is representative of a systemic problem. Given everything we now know about why identifications go wrong, researchers, the Department of Justice, and the American Bar Association have proposed a set of procedural reforms designed to reduce the risk of misidentification. Several states and cities have adopted some or all of these recommendations, though the majority of police departments in the United States have not fully implemented them. The first reform is blind administration. The officer who administers the lineup or photo array should not know which person in the lineup is the suspect. This prevents the administrator from unintentionally or intentionally signaling the correct choice to the witness through tone of voice, body language, or other cues. Even a well-meaning officer who is confident they have the right person can telegraph that confidence to a witness in ways neither party may even be aware of. Related to that is double-blind administration, where neither the officer running the lineup nor the witness knows who the suspect is. This is considered the gold standard because it eliminates any possibility of conscious or unconscious influence. Third is proper instructions. Before the identification procedure begins, the witness should be told explicitly that the suspect may or may not be present in the lineup, and that the investigation will continue regardless of whether an identification is made. This removes the pressure a witness may feel to pick someone, which research shows is a significant driver of false identifications. Witnesses who are not told that the suspect might be absent often assume the police wouldn't be showing them a lineup unless they already had the right person. Fourth is sequential presentation, as opposed to simultaneous. In a traditional simultaneous lineup, all 6 participants are shown to the witness at the same time. In a sequential lineup, they're shown one at a time, and the witness must decide about each person before seeing the next. The theory is that simultaneous lineups encourage witnesses to make a relative judgment. Which of these people looks most like the person I remember? While sequential lineups encourage an absolute judgment, does this person match my memory? The research on sequential lineups is somewhat mixed, but many jurisdictions have adopted it as a best practice. Fifth, witnesses should view the lineup individually. Multiple witnesses should never be allowed to confer with one another, and no witness should be told how another witness has responded. We saw earlier in the chapter the powerful effect that suggestion can have on memory. The Beltway sniper case, where dozens of witnesses reported seeing a white van because they heard other witnesses say it, is a vivid example of this contagion effect. And sixth, once an identification is made, the officer should immediately ask the witness to articulate their degree of confidence and document that statement. Research consistently shows that witnesses become more confident in their identifications over time. A witness who was 60% sure at the lineup may be absolutely certain by the time they testify at trial 6 months later. Capturing that initial confidence level on record is critical for giving jurors an accurate picture of what the identification was actually worth. The National Research Council endorsed all of these reforms in a major 2014 report. Roughly 19 states have adopted comprehensive reform procedures, either through legislation or judicial decision. But widespread implementation remains incomplete. Now we turn to the constitutional law. The United States Supreme Court has identified two separate constitutional frameworks that govern eyewitness identification procedures. The first is the Sixth Amendment right to counsel. The second is the due process protections under the Fifth and 14th Amendments. We will take them in order. The Sixth Amendment provides in relevant part that in all criminal prosecutions, the accused shall have the assistance of counsel for their defense. We've already discussed this right in the context of interrogations, where it plays a significant role. Here, we see it applied to a different context, the pretrial identification procedure. In 1967, the Supreme Court announced that what we now call the Wade-Gilbert rule, from two cases decided the same day, United States v. Wade and Gilbert v. California. The rule has three components. First, a suspect has a constitutional right to have their attorney present at all post-indictment lineups and show-ups. Second, if that right is violated, if the police conduct a lineup or show-up after indictment without the defense attorney present and without a valid waiver of that right, then the results of the identification cannot be introduced as evidence at trial. Third, and this is the part students often find surprising, even the witness's in-court identification of the defendant at trial can be excluded if the prosecution cannot show by clear and convincing evidence that the in-court identification is genuinely independent of the earlier tainted lineup. Why did the court say a lineup is a critical stage of prosecution? Because the consequences of a misidentification at a pretrial lineup are almost irreversible. Research shows that a witness who identifies someone at a lineup is virtually certain to identify that same person again at trial. Their memory of the event becomes anchored to the face that they selected. And when that witness takes the stand and points to the defendant and says, "That's the person," juries give that testimony enormous weight. A wrongful identification at a lineup can effectively seal a defendant's fate before the trial even begins. The defense attorney's role at a lineup is to observe, not to interfere. The lawyer watches how the police conduct the procedure, notes any suggestive practices, and uses that information later in cross-examination at trial. The attorney does not run the lineup, does not object during the lineup, and does not interact with the witnesses. Their presence serves two purposes: deterring police misconduct in the moment, and preserving a detailed record that can be used to challenge the identification's fairness at trial. United States v. Wade is the foundational case for the Sixth Amendment right to counsel at identifications, decided by the Supreme Court in 1967. The facts are straightforward. Billy Joe Wade was indicted for bank robbery. After the indictment, and without notifying Wade's attorney, the FBI placed Wade in a lineup and had bank employees view him. The employees identified Wade as the robber. At trial, the employees again identified Wade, and Wade's attorney moved to suppress both the lineup identification and the subsequent in-court identification, arguing that conducting the lineup without counsel present violated the Sixth Amendment. The issue before the court was whether the Sixth Amendment right to counsel extends to post-indictment lineups and show-ups. The court's holding was yes. A post-indictment lineup is a critical stage of criminal prosecution, and a defendant has the constitutional right to have their attorney present. The court's reasoning focused on the real-world realities of how lineups are conducted. The majority cataloged several suggestive practices that were common at that time. Everyone else in the lineup might be known to the victim, making the suspect obvious by elimination. The suspect might be the only person in the lineup whose description matches what the victim gave to police. Participants might be asked to try on an article of clothing that only fits the suspect. Police might point out the suspected perpetrator to the victim before the lineup even begins. Or the victim might be brought to a jail cell and asked to identify a single person through the bars, which is essentially a show-up with the additional suggestion of custody. The court observed that these practices, intentional or not, could undermine the reliability of the identification while leaving no visible trace that a jury could evaluate. Without a lawyer present, the defense has no way of knowing what actually happened during the lineup. And without that knowledge, effective cross-examination at trial is nearly impossible. As a result, the court established the automatic exclusionary rule for Wade Gilbert violations. If the defendant's right to counsel at a post-indictment lineup was violated, the results are inadmissible as a matter of law. There's no balancing test, there's no good faith exception. The evidence is out. Kirby v. Illinois, decided 5 years after Wade, addressed a critical limitation on the right to counsel rule. What about identifications that happen before formal criminal proceedings begin? Here are the facts. Willie Shard was robbed. The next day, police stopped Thomas Kirby and his companion Ralph Bean. When asked for identification, the two men produced traveler's checks and a social security card belonging to Willie Shard. They were arrested and taken to the police station where Shard was brought in and immediately identified both men as his attackers. At that point, Kirby and Bean had not been charged with any crime. 6 weeks later, they were indicted. Shard testified at trial about both the station house identification and made a courtroom identification. Both men were convicted. The issue was whether the right to counsel from Wade extends to identifications conducted after arrest but before the initiation of formal adversary criminal proceedings. In other words, before indictment, arraignment, information, or formal charge. The Supreme Court said no. The Sixth Amendment right to counsel attaches only after the commencement of formal adversary proceedings. A pre-indictment show-up, even one conducted at a police station with a handcuffed suspect, is not a critical stage requiring the presence of defense counsel. The court gave 2 reasons. First, efficiency. During the investigative phase, police need the flexibility to conduct identifications quickly, without waiting for an attorney to arrive. Requiring counsel before any charges are filed would impose a significant burden on routine police investigations. Second, the initiation of formal charges marks the moment at which the government has committed to prosecuting this individual, and it is that commitment that triggers the defendant's need for a full protection of legal representation. This creates a bright line that is essential for you to understand. The right to counsel at identifications is determined by when the identification occurs relative to the initiation of formal proceedings. Before indictment or formal charge, no right to counsel under the Sixth Amendment through due process still applies. Though due process still applies. After indictment or formal charge, the full Wade Gilbert protections kick in. It is worth noting that not everyone agreed with this. Justices Brennan, Douglas, and Marshall dissented, arguing that suspects are just as vulnerable to suggestive identification procedures before charges are filed as after. And several state Supreme Courts, including Alaska, California, and Pennsylvania, have interpreted their own state constitutions to require counsel at pre-indictment lineups, going beyond what the federal constitution demands. This is a good reminder that in the area of criminal procedure, state constitutions can and often do provide for greater protections than the federal floor. United States v. Ash addressed the next logical question. If defendants have a right to counsel at post-indictment physical lineups, do they also have that right at post-indictment photographic identifications? The facts. Charles Ash was indicted for armed robbery. Nearly 2 years after the indictment and on the eve of trial, the prosecutor showed witnesses a photo array of 5 color photographs to make sure they could identify Ash in court. Ash's attorney was not notified and was not present. 3 of the 4 witnesses selected Ash's photograph. At trial, those 3 witnesses made in-court identifications and Ash was convicted. Ash argued that the photo array was conducted after his indictment at a point when the right to counsel should have attached, and that his attorney's absence violated the Sixth Amendment. The Supreme Court held that a post-indictment photographic display is not a critical stage of prosecution. Defendants have no Sixth Amendment right to have their attorney present at a photo array. The court's reasoning centered on the defendant's absence from the procedure. In a physical lineup, the defendant is present. They experience the process, they can observe the witnesses' reactions, and they need a lawyer to observe on their behalf because they are uniquely positioned to absorb the impact of any suggestive conduct. But in a photographic array, the defendant is not there. They are not exposed to the witnesses are not confronted by them, and any suggestiveness in the photographs themselves can be identified and challenged after the fact by the defense attorney, who can inspect the photos and raise any concerns on cross-examination. The dissent, written by Justice Brennan and joined by Justice Douglas and Marshall, pointed out what they considered a glaring irony in the majority's reasoning. The court says a defendant needs a lawyer at a lineup because the defendant can't adequately observe what's happening on their own, and then turns around and says the defendant doesn't need a lawyer at a photo array because they're not present to observe it at all. The dissenters argued there is no meaningful difference in the risk of misidentification between a physical and a photographic identification, and that the absence of the defendant from the photo array, far from being a reason to deny counsel, is actually a reason to require it, since no one is there to protect the defendant's interest. Some scholars have noted that the Ash decision may have had a practical consequence the court did not intend. Because photo arrays do not require the presence of defense counsel, some commentators argue that police have increasingly preferred photographic identifications over physical lineups, specifically to avoid a defendant's right to counsel. Now seen the limits of the Sixth Amendment right to counsel in this context. It applies to post-indictment physical lineups and show-ups, but not to pre-indictment procedures and not to photo arrays. That leaves a significant portion of the identification process without Sixth Amendment protection. That is where due process comes in. Both the Fifth Amendment, which applies to the federal government, and the 14th Amendment, which applies to the states, guarantee that no person shall be deprived of life, liberty, or property without due process of law. The Supreme Court has interpreted this to mean that the identification procedures must be fundamentally fair. An identification procedure that is so suggestive it creates a real likelihood that an innocent person will be misidentified violates due process, regardless of whether it occurs before or after indictment, and regardless of whether it involves a physical lineup, a show-up, or a photo array. The framework the court uses to evaluate due process challenges to identification evidence has 4 steps, developed primarily in Manson v. Brathwaite, which we will look at in a moment. Step 1. The defendant must prove by a preponderance of the evidence, meaning more likely than not, that the identification procedure was impermissibly suggestive. This is the defendant's burden. Step 2. If the defendant meets that burden, the prosecution has the opportunity to respond by showing that despite the suggestive procedure, the identification itself is reliable and can be trusted. Step 3. The court evaluates reliability by considering 6 specific factors. The first is the witness's opportunity to view the offender at the time of the crime. The second is the witness's degree of attention during the criminal event. The third is the accuracy of the witness's prior description of the suspect. Did what they told police match the person they had identified? The fourth is the level of certainty the witness expressed at the time of the identification, not at trial, but at the moment of the identification itself. The fifth is the amount of time that elapsed between the crime and the identification. And the sixth is any additional evidence connecting the defendant to the crime. Step 4. The court weighs those reliability factors against the corrupting effect of the suggestive procedure. The legal standard is whether, based on the totality of the circumstances, the suggestive procedure created a very substantial likelihood of irreparable misidentification. If it did, the identification is excluded. If the reliability factors outweigh the suggestiveness, the identification comes in and the jury gets to decide how much weight to give it. This is a totality of the circumstances test, which means no single factor is automatically decisive. A very reliable witness might produce admissible testimony even after a quite suggestive procedure. A very unreliable witness might produce inadmissible testimony even without significant suggestiveness. The court weighs everything together. Manson v. Brathwaite is the Supreme Court's definitive statement on how the due process test works in practice, and it is probably the most important identification case in this chapter. Here are the facts. Jimmy Glover was an undercover Connecticut State police officer assigned to narcotics. On May 5, 1970, he and an informant went to an apartment building to purchase heroin from a known dealer. They knocked on a third-floor apartment door. The door opened 8 to 12 inches. Glover purchased 2 bags of heroin from the man at the door, handing over $20. The transaction took 5 to 7 minutes, during which Glover stood within 2 feet of the seller in natural light from a hallway window. Glover did not know the seller's identity. Afterward, Glover drove to headquarters and gave detectives a detailed description of the seller. His race, his approximate height, his build, hair color, and style, and a distinctive facial feature, high cheekbones. The detective thought that the description matched a man named Noel Brathwaite. He obtained a single photograph of Brathwaite from the records division and left it on Glover's desk. 2 days later, Glover came back to the office and saw the photograph. He immediately identified the person in it as the man who had sold him the heroin. There was no photo array. There was no lineup. Just one photograph. Brathwaite was arrested and charged. At trial, Glover testified about his identification of the photograph and made an in-court identification. The jury convicted. Brathwaite appealed, arguing that the single photograph identification was so suggestive that it violated due process and should have been excluded from evidence. The Court of Appeals agreed and reversed the conviction, reasoning that a per se rule of exclusion should apply whenever an identification is both unnecessarily suggestive and unnecessary, meaning that the police could have easily used a proper photo array instead. The Supreme Court reversed. The majority, written by Justice Blackmun, rejected the per se exclusion rule and adopted instead a totality of the circumstances reliability test that was just outlined. Then the court applied that test to Glover's identification. On opportunity to view, Glover stood 2 feet from the seller for 5 to 7 minutes in good natural light. This was strong. On degree of attention, Glover was a trained undercover officer who knew he would need to identify the seller later. This was also strong. On accuracy of the prior description, Glover gave detectives a detailed, accurate description within minutes of the transaction. This was strong. On certainty, Glover testified that there was no doubt whatsoever about the identification. This was strong. On time between the crime and the identification, there were only 2 days. This was strong. The court concluded that these reliability factors overwhelmingly outweighed the suggestiveness of the single photograph procedure, and the evidence was admissible. Justice Marshall dissented, joined by Justice Brennan, in an opinion worth reading carefully. Marshall argued that the majority's analysis is fundamentally flawed because it imports the question of the defendant's probable guilt into the constitutional analysis. He contended that certainty is a worthless indicator of accuracy. Of course, an officer who is about to testify for the government that pays his salary will say that there is no doubt whatsoever. He also challenged the majority's characterization of the observation as extensive, arguing that the actual face-to-face time may have been as brief as 15 to 20 seconds. Marshall concluded that when you look honestly at what happened, almost everything that could have been done wrong was done wrong, and that the majority has in effect given police license to convict the innocent by endorsing an after-the-fact reliability review that is far too deferential to the prosecution. Manson v. Brathwaite remains the controlling framework for due process challenges to identification evidence today. Perry v. New Hampshire, decided in 2012, was the Supreme Court's first major identification case in more than 35 years, and it addressed an important threshold question. Does the due process reliability framework apply even when the suggestive identification was not created or orchestrated by the police? The facts. Nubia Blandon looked out her fourth-floor kitchen window at about 2:30 in the morning and saw a tall, African-American man walking through the parking lot, peering into cars. She watched as he opened the trunk of her neighbor's car and removed a large box. She called police. Officer Nicole Clay responded, found Barry and Perry in the parking lot, and placed him in the custody of another officer while she went upstairs to speak with Blandon. Officer Clay asked Blandon to describe the suspect she had seen. Blandon looked out her kitchen window, the same window she had been watching from, and pointed at the man standing in the parking lot in handcuffs next to a police officer. That was her identification. She was pointing at Perry, who was the only person in the parking lot under police restraint. A month later, Blandon was shown a photo array, which included Perry's photograph. She was unable to identify him. At trial, she identified Perry in court as the man she had seen that night. Perry was convicted. Perry argued that the identification was so suggestive, a single individual in handcuffs standing next to a police officer, that the trial judge was required to screen the identification for reliability before allowing Blandon to testify. The Supreme Court disagreed. Justice Ginsburg, writing for the majority, held that the due process reliability screening only applies when law enforcement has itself created the unnecessarily suggestive circumstances. Where the police did not arrange the suggestive situation, where the suggestiveness arose from the circumstances rather than from any police misconduct or design, due process does not require a pretrial reliability hearing. The jury is the appropriate body to evaluate the witness's credibility, and cross-examination and jury instructions are adequate tools for that purpose. The court reasoned that the primary purpose of excluding suggestive identification evidence is to deter police from using improper procedures in the future. Where the police did not create the suggestive circumstances, there is no misconduct to deter, and the rationale for exclusion does not apply. Justice Sotomayor dissented and made a compelling point. She argued that the suggestive circumstances in Perry were, in fact, police created. It was Officer Clay's decision to ask Blandon for a description while Perry was standing in handcuffs in the parking lot below her window. The majority, she argued, draws an artificial line between intentional and inadvertent police-created suggestiveness. And more fundamentally, the concern about eyewitness misidentification does not disappear just because no officer intended to create a suggestive identification. The risk to the defendant is the same either way. Perry v. New Hampshire tells us that the scope of the due process protection has a meaningful limit. Police involvement in creating the suggestive circumstances is a prerequisite for the constitutional reliability screen to apply. We now shift from eyewitness identification to scientific identification. In this part of the chapter, we are dealing with a different kind of evidence. Not a witness's memory, but laboratory analysis, expert testimony, and forensic science. And the question is, how do courts decide whether a particular scientific technique is reliable enough for a jury to hear? The answer depends on which standard a given jurisdiction follows. There are two major frameworks in use in the United States today. The first and older of the two is the Frye test, established in 1923 in a case called Frye v. United States. The Frye court was dealing with the defendant who wanted to introduce the results of a polygraph examination at his trial. The court declined, and in doing so articulated a general standard. For scientific evidence to be admissible, the underlying technique must be sufficiently established to have gained general acceptance in the particular scientific field to which it belongs. If the relevant scientific community, the experts in that discipline, have accepted the method as valid, it can come in. If they haven't, it cannot. Fry is a conservative standard. New or emerging science, no matter how promising, has to earn acceptance in the scientific community before it crosses the courtroom threshold. This can take years, but the upside is that juries are protected from being misled by techniques that haven't withstood the scrutiny of peer review and replication. The second framework is the Daubert test, established by the Supreme Court in 1993 in Daubert v. Merrill Dow Pharmaceuticals. Daubert made federal judges more active gatekeepers. Under Daubert, judges do not simply ask whether the scientific community has accepted a technique. They independently evaluate whether the technique is based on sufficient data and reliable methodology, whether it has been tested and subjected to peer review, whether there is a known or potential error rate, and whether it is generally accepted in the relevant field. Daubert is broader and more flexible than Fry, but it also places a heavier burden on judges, who must now engage in a substantive evaluation of scientific methodology that they may have little training to conduct. Today, roughly 23 states follow Fry and 21 follow Daubert. In most cases, the two standards produce the same result. Astrology, for example, would fail under both. DNA would pass under both. The real differences emerge with newer or more contested techniques, where the scientific community has not yet reached a consensus. It is also worth noting that even under Daubert, the opposing party can challenge the reliability of evidence that has been admitted. Admissibility under Daubert does not mean the evidence is conclusive. It just means that the jury gets to hear it and decide how much weight to give it, with both sides presenting their own experts. DNA is the molecule that contains a person's genetic code and is present in every cell of the human body: blood, saliva, hair, skin cells, semen, bone. Every individual, with the exception of identical twins, has a unique genetic code. That uniqueness is what makes DNA so powerful as an identification tool. When DNA is recovered from a crime scene, from a bite mark, a cigarette, a sweat-stained glove, a strand of hair, it can be compared to a known sample from a suspect. If the patterns match, a forensic expert will testify about the statistical probability of that match, occurring by chance in the general population. A match might be expressed as occurring in only 1 in 100,000 people or 1 in 1 billion, depending on the number of genetic markers that were compared. That kind of statistical precision is something eyewitness testimony can never provide. DNA serves three primary functions in the criminal justice system. First, detection, connecting an individual to a criminal act based on biological material at the scene. Second, investigation, either including or excluding a suspect early in the investigation before charges are ever filed. And third, establishing guilt or innocence at trial, including, and this is critically important, establishing the innocence of people who have already been convicted. The Innocence Project at Cardozo Law School has secured more than 375 post-conviction DNA exonerations in the United States. The average exoneree served 14 years in prison before being freed. 60% of those exonerees are African American. 21 were on death row. These are not abstract statistics. They represent specific people who were wrongfully imprisoned, often for decades, because the other evidence against them looked compelling at the time. DNA is not, however, a perfect tool. There are 4 significant limitations. Contamination is a persistent risk. Samples can be mixed up, degraded by heat or moisture, or tainted by trace materials from investigations. Laboratory error is also a real concern, whether in the analysis itself or in the statistical calculations used to express the strength of a match. Third, even a genuine DNA match does not always prove guilt. There can be innocent explanations for the presence of a suspect's DNA at a crime scene, such as prior consensual contact. And fourth, DNA is not always relevant to the central legal issue. In a rape prosecution where consent is the contested question, DNA evidence identifying the defendant as the source of the biological material does not resolve whether or not the encounter was consensual or not. In 2015, a major investigation revealed that nearly every forensic examiner in the FBI's microscopic hair comparison unit had given exaggerated or scientifically unsupportable testimony in 96% of trials reviewed, spanning a 20-year period from 1980 to 2000. 35 defendants in those cases had been sentenced to death. This scandal is a reminder that scientific evidence, even evidence presented under the authority of the FBI laboratory, can be corrupt, and that the Frye and Daubert gatekeeping functions are not just formalities. On the database side, the Combined DNA Index System, known as CODIS, is the national DNA database maintained by the FBI. It integrates DNA profiles from all 50 states and the federal government. As of October of 2021, CODIS contained over 14.8 million profiles and had assisted in nearly 575,000 investigations. All 50 states collect DNA from convicted felons. 28 states and federal government also collect DNA from individuals who are just arrested, not convicted, but arrested for certain offenses. Maryland v. King addresses one of the most significant Fourth Amendment questions raised by the expanding use of DNA databases. Can police collect DNA from an individual who has been arrested but not yet convicted without a warrant? The facts. In 2009, Alonzo King was arrested in Maryland for first and second degree assault. As part of the routine booking process under a Maryland statute, a police officer swabbed the inside of his cheek to collect a DNA sample. That DNA sample was uploaded to CODIS, where it matched a DNA profile taken from a rape victim in 2003, an unsolved case. King was subsequently charged and convicted of the rape. King challenged the DNA collection as an unreasonable search under the Fourth Amendment. He had not been convicted. He had not consented to the swab. There was no warrant, and the DNA collection was not connected to the assault charges for which he had been arrested. It was used to solve an entirely separate cold case. The Supreme Court upheld the constitutionality of the Maryland DNA Collection Act in a 5-4 decision. Justice Kennedy, writing for the majority, held that collecting a DNA buccal swab from an arrestee is a reasonable search under the Fourth Amendment. The majority's reasoning had two components. First, arrestees have a reduced expectation of privacy. They are already in the custody of the state, they are subject to booking procedures, and their identities and criminal histories are legitimately subject to governmental inquiry. Second, a cheek swab is a minimal physical intrusion, far less invasive than a blood draw, and the government's interests in conducting it are substantial. Identifying the arrestee accurately, learning their criminal history, assessing any risk they may pose, and potentially exonerating an innocent person who has been incorrectly identified. The court analogized DNA swabbing to fingerprinting and photographing, both of which are routine components of the booking process that courts have long upheld as reasonable. DNA, the court said, is simply a more precise form of identification, the same basic practice carried forward with modern technology. Justice Scalia dissented in an unusual alignment with Justices Ginsburg, Sotomayor, and Kagan. Scalia argued that the majority's identification rationale is pretextual. The DNA swab is not used to identify the arrestee in any meaningful sense because the results are not returned until weeks or months later, well after any identification purpose has been served. The real purpose, Scalia wrote, is to solve cold cases, and permitting warrantless searches for that purpose, he argued, is a dangerous expansion of government power with no principled limiting principle. He ended his dissent with the memorable observation that the majority's decision taxes the credulity of the credulous. Maryland v. King remains the law today. It is an important case not just for DNA law, but for Fourth Amendment jurisprudence more broadly, as it illustrates how the court balances individual privacy rights against governmental interest in criminal investigation and public safety. We end the chapter with polygraph evidence, which in many ways represents the opposite end of the scientific spectrum from DNA. Whereas DNA has been embraced by courts as one of the most reliable tools in the evidentiary arsenal, polygraph evidence remains almost universally excluded. A polygraph, commonly called a lie detector test, works by measuring physiological responses to questions, blood pressure, respiration rate, and galvanic skin response, which is essentially perspiration. The theory is that deception produces stress, and stress produces measurable physiological changes. A trained examiner reviews the physiological record and offers an opinion about whether the subject's answers were truthful or deceptive. The general rule across virtually all states and federal courts is that polygraph results are not admissible at trial. The technique fails under both the Frye and Daubert standards. Under Frye, the scientific community has not accepted polygraph testing as reliably valid. The field remains deeply divided. Under Daubert, independent judicial evaluation of the research leads to the same conclusion. There's insufficient basis for confidence in the test's accuracy. The most authoritative assessment came from the National Research Council of the National Academy of Sciences in 2003, which conducted a comprehensive review of the polygraph literature and concluded that there is little basis for the expectation that a polygraph test could have extremely high accuracy. The council identified a number of specific problems: the lack of standardized training and administration, the ability of subjects to defeat the test through countermeasures, controlled breathing, physical discomfort, or mental exercises, the absence of reliable data on error rates across different ethnic and demographic groups, and the simple fact that innocent people under stress may register the same physiological responses as guilty people who are just lying. In the United States v. Sheffer decision decided in 1998, the Supreme Court upheld the constitutionality of a military rule that categorically prohibits the introduction of polygraph evidence at court-martial. Edward Sheffer, an Air Force member charged with methamphetamine use, sought to introduce a polygraph he had passed as evidence of his innocence. The trial court excluded it, and the Supreme Court affirmed. Justice Thomas, writing for the majority, identified two primary justifications for the exclusion. First, keeping unreliable scientific evidence away from juries is a legitimate governmental interest, and the polygraph's reliability remains seriously in doubt. Second, allowing juries to hear polygraph evidence would create a real risk that they would give undue weight to the examiner's opinion, essentially treating the lie detector as a substitute for their own evaluation of the evidence. The jury's role as the ultimate fact finder in a criminal case is foundational, and evidence that tends to usurp that role is appropriately excluded. The one exception worth knowing: New Mexico is the only state whose Supreme Court has ruled that polygraph evidence is admissible at trial, subject to the trial judge's discretion. A handful of federal district courts have also permitted polygraph evidence under limited circumstances, typically when both parties agree to its admission. But these are exceptions to a very firm general rule. Researchers continue to develop alternative deception detection technologies. Voice stress analysis, thermal facial imaging, and functional brain imaging have all been explored. As of now, none of these has achieved legal admissibility in any jurisdiction. The reliable lie detector remains, for the time being, a goal rather than a reality. Let me bring everything together with the 6 key takeaways from Chapter 9. First, eyewitness misidentification is the leading cause of wrongful convictions in the United States. The Jennifer Thompson and Ronald Cotton case illustrates that even the most careful, engaged, and motivated witness can be catastrophically wrong. This is not a failure of character. It is a function of how human memory and perception work under stress. The constitutional protections we have studied today exist because of cases like this. Second, the Sixth Amendment right to counsel at identification procedures is more limited than you might expect. It applies to post-indictment physical lineups and show-ups, where the court has found that defense counsel's presence is necessary to protect the defendant and preserve a fair record for trial. It does not apply to pre-indictment procedures under Kirby, and it does not apply to photographic identifications under Ashe. Understanding exactly where that right begins and ends is essential. Third, due process fills in the gaps. The Fifth and 14th Amendment due process framework applies to all identification procedures at all stages, regardless of whether counsel was present or not. The test, as established in Manson v. Brathwaite, is a totality of the circumstances reliability analysis. The court weighs the 6 reliability factors against the corrupting effect of any suggestive procedure and asks whether there is a very substantial likelihood of irreparable misidentification. Fourth, police involvement matters. Under Perry v. New Hampshire, the due process screening mechanism only applies when law enforcement created or arranged the unnecessarily suggestive circumstances, when suggestiveness arises from the situation itself rather than from police conduct. The jury evaluates the identification's credibility through the ordinary mechanisms of cross-examination and instruction. Fifth, DNA has transformed criminal investigation and the pursuit of justice for the wrongfully convicted. It passes both Frye and Daubert with ease. It is admissible in virtually every jurisdiction, and it has exonerated hundreds of people who should never have been convicted. At the same time, it's not infallible. Contamination, lab error, and questions of relevance mean that DNA evidence must be evaluated critically, not accepted uncritically. And under Maryland v. King, collecting DNA from arrestees as part of routine booking is a constitutionally permissible search under the Fourth Amendment. Sixth, polygraph evidence remains inadmissible in virtually all courts. The science has not earned acceptance under either Frye or Daubert, and the courts continue to exclude it on the grounds that its reliability is insufficient to justify placing it before a jury. New Mexico remains the sole exception. Taken together, the cases and concepts in this chapter reflect a consistent and difficult balancing act. On one side of the scale is the individual defendant's interest in fair procedures that minimize the risk of wrongful conviction. On the other side is society's legitimate interest in effective law enforcement, reliable identification of perpetrators, and the conviction of people who are actually guilty. The Supreme Court has not always drawn these lines in the same place, and reasonable people, including the dissenting justices in virtually every major case in this chapter, disagree about where those lines should fall. Your job as students of criminal procedure is not just to know where the lines are, but to think critically about whether they are drawn in the right place. That concludes Chapter 9. Thanks for watching, and I'll see you in the next lecture.